first want to say, and I think I speak for all the lawyers here, thank you for your service this week. Thank you for your patience. Thank you for your attention. Thank you for the service you've done to your community this week. No one takes this lightly. But you took an oath to follow the law. And the law says that in some murders, the circumstances of the offense are so aggravating that they cannot be tolerated by society, and they cry out for the ultimate punishment. This is that case. There's a quote by F. Scott Fitzgerald that says, "Show me a hero, and I'll write you a tragedy." Sean Bolton was a hero. Not in the big, dramatic, leaping tall buildings sort of way that we sometimes think about heroes, but in the quiet, everyday way that people in our society serve their community. First, as a Marine, serving his country, and then as a neighborhood police officer, the kind that would wave to Miss Crutchfield and others to check on the elderly people in the neighborhood to make sure that they were okay. And the loss of his life was a tragedy for this community. It was a tragedy for this community. A tragedy written by Tremaine Wilbourn. Because when Tremaine Wilbourn blew open Sean's face that night and unloaded 8 more shots into his broken body as he lay dying in the street, he tore at the fabric of this community. The judge has told you how you're to consider victim impact evidence. This is not an aggravating circumstance that you can consider when you're looking at the other aggravating circumstances. But you heard from Brian Bolton and you heard from Officer Boyd about that impact. You should follow the judge's instructions about when and how you're to consider that. So let's talk about the aggravating circumstances in this case. That the murder was committed against a law enforcement officer who was engaged in performance of official duties, and the defendant knew or reasonably should have known that such victim was a law enforcement officer. The state has proven this aggravating circumstance beyond a reasonable doubt. We know that Sean Bolton pulled up that fateful night to where that car was parked. And we know he tried to perform the duty that he was there to perform, to protect the community, to investigate suspicious activity, to check on individuals. And there's no way that Tremaine Wilbourn didn't know what his purpose was. He unloaded those 11 shots with deadly accuracy, one after another, after another, after another, extinguishing the life of Sean Bolton. Prior violent felony. The defendant was previously convicted of 1 or more felonies other than the present charge, the statutory elements of which involve the use of violence to the person. And I talked to you in opening statements about how you are to consider not only the proof that we put on during this phase of the trial, but you're to consider all the proof that you've heard all this week, and considering both the aggravating and the mitigating circumstances. And what you heard at trial was that the defendant stipulated to having been convicted of a prior crime of violence. And at sentencing, you heard that that crime of violence was armed bank robbery, and carrying a weapon during a crime of violence. And you introduced into evidence for those certified copies of conviction for those offenses. And you heard the proof about what those offenses involved. And they involved Tremaine Wilbourn and another person entering a bank, the individuals inside, armed, both of them, with masks, and demanding money. Now, the defense seems to want you to believe that Tremaine just somehow got drug in with an older individual and followed along. They traveled from Memphis to Covington, Tennessee, over an hour away. He made a decision to get in the car. He made a decision to go armed. He made a decision, just like he made decisions in this case about his behavior and his actions. And they also said to you, there weren't really any victims to that crime. I submit to you that having a gun pointed at your face and by force having things taken from you makes you a victim. Committed to avoid arrest or prosecution. The murder was committed for the purpose of avoiding, interfering with, or preventing a lawful arrest or prosecution of the defendant. And again, the proof you heard at trial that the defendant stipulated he was a convicted felon, and he knew that he wasn't supposed to be around criminals and crime and people committing criminal acts. He wasn't supposed to be around drugs or use drugs. And he wasn't supposed to carry a weapon. And what you heard was, maybe that marijuana, maybe that wouldn't have gotten him violated, even though he'd already gotten in trouble while he was on release for smoking marijuana. Maybe. But yes, definitely, he knew that gun was going to send him back to prison. Again, it's essentially the same proof that you've already used to determine that he acted with premeditation and intent that night. 11 shots, 9 striking Officer Bolton. All of them kill shots outside that vest. Getting away, not being arrested, not going back to prison, that's what happened. And then he fled and carjacked Desert Godfrey. Because, what did he say to him? I just shot a police officer. Give me that car. Because I'm not going back. That's what was going on. Then you heard of the proof during this phase of the trial that he was on supervised release. Again, he was told not to have that gun or be around illegal activity or drugs. And that he was thrown out of the halfway house because he couldn't follow the rules. And we're going to talk more about that. We're going to talk about that. We're going to talk about what you should or shouldn't consider or what weight you should give to mitigation. That he'd been violated and sent back to prison once before, after he'd gone to that halfway house, that he'd briefly been sent back. And that gun would send him back again. On June 6, 2015, heard the testimony that he told his probation officer that had been stopped and questioned by an officer, and he wasn't real happy about it. And then on June 9th, he posted to his Facebook page, "Police try to snatch me up. They gonna need backup. Acting strange around me. Gonna get up, clapped up." Tremaine Wilbourn decided that his freedom that night was more important than Sean Bolton's life. State submits to prove that aggravating circumstance beyond a reasonable doubt. So let's talk about mitigation. Mitigation isn't a numbers game. It isn't, there's 10 things here and 4 things here, so that 10 must add up. That's not the way it works. You have to look at it and consider it for the ones, whether or not it's mitigating at all. And you're the one that decides, if you find that it's mitigation, what weight to give it. So let's talk about it. The youth of the defendant. The defendant was 29 years old when this happened. And there was a lot that had happened in his life up to that point. He began getting in trouble around the time that he was age 7. He had a history of delinquent and criminal behavior as a juvenile. Some of it violent. As a child, he was picked up for repeatedly throwing rocks at children in the neighborhood. Then the next time he gets in trouble, he shot at a car 6 times. He shot at a car 6 times of another juvenile. And he was thrown out of school for bringing a knife to school. Then at age 19, he commits the armed bank robbery. And while in custody, you heard testimony that there were 22 incidents when he was fighting. One for having a weapon, and several times that he was threatened or was disrespectful to people in authority. And what you also heard was, I don't like people in authority. I have a problem with authority. And when he was released, he went to the halfway house, and then he was thrown out of the halfway house for gang signs and gang activity. And then he failed to comply with the conditions of his release. Multiple drug screens that came back positive for drugs. And 14 months later, Officer Bolton lay dead in that driveway on Summer Lane. The capacity of the defendant to appreciate the wrongfulness of his conduct. The state submits there has been absolutely no proof of this factor. There was some testimony that he had depression, some symptoms of PTSD, but he also received treatment. Benefit of having gone and been on federal release, he was seeing someone for those things. He was being treated. There was no testimony whatsoever from any mental health or medical professional who said that the problems that he had, the symptoms he had, this depression, affected in any way his ability to make decisions or his actions on that night. But what you did hear, he'd also been diagnosed with antisocial personality disorder. And that disorder is marked by symptoms of an individual who doesn't have any empathy, shows no concern for other people, no concern for right or wrong, that he was angry and aggressive, that he sought out conflict, and that much of his interactions with people were marked by conflict. His education. Well, it's true that he did not finish high school because he was thrown out in the 11th grade for bringing a weapon to school. But he was able to get his GED. He was given opportunities while he was on release and in custody for vocational training. And he also took some college courses. The state submits, going back, that if you find this mitigating, you should give it very little weight. And the state submits that this, in fact, you should not find to be a mitigating factor. That there's not been proof to show you that this should be mitigation. And again, the state submits that he was given opportunities for education. He just didn't avail himself of those. Family background. One of the rest of the factors that you have to consider have to do with the defendant's family and that family dynamic and his mother and that background. Clearly his mother was absent from his life and she had problems. But Mr. Wilbourn had something else. He had Sandra Richardson, who by all accounts is an amazing woman, who took him in and did the absolute best she could do. She fought for him even though he wasn't biologically related to her, because she wanted to keep those siblings together. She did the very best she could for him. She provided for him the absolute best way she knew how. And she tried to instill some discipline. She tried to put him on the right path. And when he committed that bank robbery, she continued, as did his sister and other family, to stand by him, to support him, to try to get him to take advantage of the opportunities that he was being provided by the probation service. He had a chance. He had a chance to turn things around, and he rejected it. He got thrown out of the halfway house for not following the rules. He lost his job with Staff Line because he threatened another coworker. More job opportunities were set up for him, but he didn't make the appointment. When he said, "I'm having problems adjusting," he was given help and sent to counseling. He was given additional job training, skills training, drug treatment if he needed it. He turned away from all of that. He made the choice not to turn it around. He made the choice to continue to be angry and get into conflicts and be violent. I'm not sure it's a voluntary surrender. If you know the Marshal Service is closing in on you and you turn yourself in, you give that whatever weight you want to give it. Do you consider Reverend White's testimony, who clearly is another person who tried to help him and put him on the right path, works in the community to put young men and women on the right path? Residual doubt. Ladies and gentlemen, there is no doubt that Tremaine Wilbourn is the one who blew Officer Bolton's face apart and then put 8 more shots in him. There's no doubt of why he did it, that he decided to shoot him those 9 times, and that he intended to kill him. There's no doubt left. You made that determination. You decided it already. And the next thing to do to give whatever weight you give to those mitigating circumstances, to weigh them against the aggravating circumstances. The state submits when you do that, you'll find that those aggravating circumstances outweigh any mitigation you find in this case. This case really comes down to, your decision right now comes down to what the case has always come down to. The choices that were made by Tremaine Wilbourn in that 1 to 2 minutes after he had blown Sean's face apart, and those 8 shots that came next that ensured that Sean's life would be taken from this community. And if we could replay it like a horrible slow motion movie, we would see the choices that these 2 men made for their lives play out. Sean lying in the street, trying to hold his face together with his own hands, trying to call for help. Laying in there in the street, thinking about the birthday dinner he'd never make it to, thinking about the nieces who depended on him, and the relationship he was building with his brother that would be cut short, trying to hang on, hearing his brothers in blue racing towards him in the distance. Hopefully, he saw the sweet face of Miss Crutchfield, the nice lady who waved to him in the neighborhood. Hopefully, he heard the voice of Christopher Lanier telling him, no one else is going to hurt you tonight. We're going to try and get you some help. Just hang on. Hopefully, he wasn't thinking about the awful, searing pain. Hopefully, he wasn't thinking about the unspeakable brutality of what had been done to him. Hopefully, he lay there thinking of pink unicorn, his family that loved him, his Marine Corps buddies. Hopefully he didn't sense the decisions that were being made by Tremaine Wilbourn in that same 1 to 2 minutes. Hopefully he didn't sense that convicted felon Tremaine Wilbourn was making cold, calculated decisions a few feet away. Hopefully he didn't sense his life about to end. And hopefully, ladies and gentlemen, he did not see coming. Shot 2, shot 3, shot 4, shot 5, shot 6, shot 7, shot 8, shot 9. Hopefully that's not what was in his mind, because we know in Tremaine Wilbourn's mind he'd made the decision already that his freedom was more important. You've heard the aggravating circumstances, and you've heard the mitigating circumstances, and the only thing left to do in this case, ladies and gentlemen, the only thing left to do is to follow the law. And if you follow the law in this case, the punishment shall be death. Thank you.
Thank you, Ms. Garter.